Good morning. See, at the time of remand, whether you can claim bail application or not is a $1,000 question, which we should understand. According to me, yes, you can claim uh, bail or discharge. So, the discharge provision not only applies during process of trial under warrant cases and sessions cases, but if you go through section 59 of the CRPC, another provision for discharge is there. Any person arrested shall not be discharged except order of the court. So discharge is there. 167 is a remand procedure wherein the constitutional mandate that a person should not be detained for more than 24 hours after the arrest must be produced before the court. That is independent section. But the police officer, if requires, that is custody, either police custody or judicial custody requires, he has to invoke section 167 CRPC, which regulates how the remand is being granted. The police officer must seek requisition for remand along with copies of the diaries. That means once FIR is filed, 172 case diary is being created. That means contains FIR, 161 statement of the witnesses, accident report, seizure, arrest card, so many. So the remand requisition must accompany all these documents. Then what happens, how you can object for remand? You can object for remand stating that the material placed before the court is not sufficient to consider that the accused prima facie committed an offence punishable for non-bailable offences or bailable offences. If you are able to satisfy the court that the offences made out in the remand report and the copies of CDs forward along with the remand requisition report, but it did not disclose non-bailable offence, then you can also file application under 437 class 2. That says that if the court feels that the arrested accused was produced without any material that he committed any non-bailable offence, but there are offences of bailable in nature, then the court can release him on bail. So you have got right to file application for instant bail. Another question arises, the Arnesh Kumar case says that there should not be unnecessary arrest. The offences are punishable within 7 years even though it is non-bailable. You can also refer that case. So 167 at the time of remand, the court should consider all these things. For that, a judgment is there. Kindly keep this judgment every time on your file. The division bench says neither 167 CRPC nor Rule 6 of the Criminal Rules of Practice speaks about the issuance of written notice to the accused, counter affidavit from the accused, and elaborate inquiry in the remand proceedings. However, since an order of remand affects the personal liberty of the prisoner, the procedure there must be fair, reasonable, to comport with the requirement of Article 21 of the Constitution of India. It is for these reasons that the accused is given right of hearing during the remand proceedings. Therefore, Union of India versus Diwan Mujibir 2022-1 Law Weekly Criminal 467 Madras Division Bench. Union of India Diwan Mujibir 2022-1 Law Weekly Criminal 467 Madras Division Bench. So you have, what you have to do, you have to go through the papers, or even you can ask the learned judge to permit you to peruse the copies of CDs. forwarded along with the remand requisition report. Or straight away you have to file Section 59 to discharge the accused and 437 Class 2 CRPC for instant bail by citing this judgment as well as Arnesh Kumar judgment. I think you understand the concept of this judgment, and kindly go through all the provisions of 167 clearly. Best wishes. Happy Women's Day for all brothers, all sisters, mothers, daughters, granddaughters, and beloved.